How are you? Hello.
Hi, Jim.
Jim. James.
How you doing?
Very well, and you?
Great.
Alrighty. Well, we have 20 minutes with you,
Okay.
and there are 3 minutes for an opening and 2 minutes for a close, and begin whenever you're ready.
Okay, thank you. Well, I want to thank everybody for being here and taking the time out of your day to interview all of us and read all the telephone books we dropped off for you. Our lovely qualifications. I've been a trial lawyer now for 35 years. In fact, as of yesterday, I was just telling Mr. Sasso, yesterday marked my 35th year. I love what I'm doing. I really, really love being a trial lawyer. But I would really enjoy transitioning over and being a judge here on the Court of Appeal. My background has been handling a wide variety of cases, from commercial matters, products liability cases, simple auto cases, bail bond cases, real estate, you name it. If it can come up in court, whether in the trial court or the Court of Appeal, I'm likely to have touched one of them. Over here, I'll get to do even more in terms of variety. I've done a limited amount of criminal work, mostly now in the Virgin Islands where I'm a member. They appoint you to criminal cases there. I've always enjoyed working in a collegial setting. I know the judges over here well enough to know that I would enjoy working with each and every one of them. And it would also give me a chance to continue doing the professionalism work I've been doing, to get out in the community, whether in the law schools, bar associations, or whatever, and continue with that work. So the only other thing that I would bring up to y'all is, as a mediator, I've touched on many different kinds of cases for different parties, whether it's an individual, a large corporation, and a variety of cases again. And to me, it's very satisfying and rewarding to have your colleagues choose you to help them settle their cases. So hope that gives you a little bit of background, and I'm, of course, happy to answer whatever questions y'all have.
Jim?
Tell us about your experience at the governor's office. You've been here numerous times now, right?
Yes, I have.
Okay. So tell us, kind of since the last time we saw you, what happened then?
The last time I applied was back in 2013, and Governor Scott was the governor at that time. Rand Wallace was appointed. I've made it through the JNC and through the 6 list down to the short list each time, both with Governor Christ and with Governor Scott. In terms of exactly why somebody else has gotten it instead of me, I'm afraid I'm not the person who can really answer that. I felt like the interviews went well. Each time it was a good conversation, and I guess the governor had something else in mind other than me that particular time, but hopefully this is going to be the charm. So,
is there anything you learned from that experience that you would apply should you go up again?
I think so. Each time it was a very comfortable, cordial kind of conversation. I think if anything, I might be even more direct than I was before. And, I mean, I've asked to be appointed. We've answered all the questions, but that's, if anything, that would be the difference.
Okay. What would be your response to the argument some people make that you need to be a judge to be an appellate judge first?
I don't think trial judges are in any way disqualified from being an appellate judge, but being an appellate judge is a lot more like being a civil litigator. A trial lawyer gets into the issues very deeply. They go through all the top to bottom. They read all the cases, they look at all the issues, they turn it around and turn it around. A trial judge has to rule on 10 or 15 motions every morning and then conduct a trial during which he or she has to deal with, 20, 30, 40 objections and issues during the day. I'm not saying they have to make snap decisions, but they have to make quick decisions. They don't have the luxury that a lawyer does to really get in deep. Here at the Court of Appeal, you obviously get in very deep yourself, plus you have your law clerks to help you get in deeper. You have the parties briefed. So it's really, in my mind, more akin to the practice of law and resolving issues the way an attorney does it, rather than a trial judge gets to do it. You're not having to make snap decisions or quick decisions as a judge on the Court of Appeal like you would as a trial judge. Like I said, I'm not saying the trial judges can't do it, but that's not what they do every day.
What do you perceive as the greatest need of the 5th DCA, and what would be your plan to address that need?
Well, they obviously have a heavier caseload, which is why the legislature created the position. I've got an extremely good work ethic, as I'm sure everybody else who's applied has, but I've handled a number of cases, sometimes come in, been associated on a case when it's close to trial time, which means you've got to get in, understand the legal principles, learn the facts, and deal with people on complex matters, and figure out where you're going with it, and then take the case to trial or handle the appeal. I think those same kind of characteristics and qualities would work well here in terms of being able to get in here, jump in, start working right away, take on a heavy caseload. And again, I enjoy working in a collegial manner. You know, to me, it's a lot of fun to have the give and take with your law partners or people on committees or whatever about what the issues are, and that would be something I would very much look forward to here.
This is my last question. I'll defer to everyone else. What is the $1 Million Advocates Forum? What is that?
If you have gotten a jury verdict or a settlement of $1 million or more, you belong to that entity if you wish to. A colleague of mine who was a defense lawyer down in the Virgin Islands became a plaintiff's lawyer in the Virgin Islands, and he and I always stayed in contact. At one point he had a case in which a youngster fell out of a second floor window, and he had hired the experts and worked everything up. I then got in at the time it was time to assist with expert depositions and get ready to go to trial, and we settled that case for well in excess of $1 million, but in a confidential amount. The reason I think that's important, the reason I include that, some people think of me as a defense lawyer. I'm not just a defense lawyer. I'm a trial lawyer and an appellate lawyer.
I'm glad you actually included it, because I think that was the question, basically. What groups do you belong to that we should know about? And that's
Right.
why I just didn't know what it was. So thank you.
Sure.
So it's not a good group if you're a defense lawyer.
Right.
Well, yeah, no, but I'll have to say, I am a member of the $1 Million Club on the defense side. If you try enough cases, you're going to wind up with $1 million hanging off the other side of it too.
But in all, you know, to be serious, you've been before this committee on a number of occasions, deemed you to be qualified, and I think if there was ever a non-judge that could do the job, I think you demonstrated that you could do a very good job.
Well, thank you.
I don't have any questions.
Okay.
I have a question.
Yes.
Tell me how you would go about balancing collegiality and groupthink. I mean, you know, are you coming in there as a pledge?
No.
With a group of people? You know, this is a well-settled group that has been intact for quite a while, and you would be the new person. How could you get around that?
For one thing, I know most of the judges very well here on the court, some better than others. So I feel like I would truly be coming in as an equal. I may not know right now which parking space would be mine or which office would be mine, but in terms of understanding how to analyze law and read the record and all the rest of that, I don't really feel like I would be giving up anything to anybody else. And again, I know the judges very well. I never felt like, even during oral argument or briefing or anything else, that anybody has ever tried to exert their superiority here. To me, that's one of the nicest things about this court is the collegial atmosphere between the bench and the bar. And that's one of the things I like most when you come over here for an oral argument. It really is like you're having a discussion, not with your classmates because they're the judges, but you know, you really are talking about issues. It's not somebody trying to haze you or harass you or in any way other than just question you on what really matters in the case. So I don't think that would be a problem. I think I could fit in very well, and again, I've always enjoyed the collegial atmosphere.
In the interest of full disclosure, Jim has represented Disney in the recent past, and so I'm going to stand at this point.
I'm the new person here. I'm newer at this than you are, Jim. But I know you well from bar activities and everything else in the Orlando area, and maybe all of these people already know all this about you, but can you describe your activities with ABOTA and developing CLEs, presenting on CLEs, all the great things you've done with professionalism and ethics in the Central Florida area?
Thank you. I'd be happy to do that. I'm not somebody who just complains if I see a problem. If I see something that I think I can help with or help fix, I try to get in there and do it. I've been on the Orange County Bar's Professionalism Committee, I'm guessing probably 15 years, however long it existed. It was in business a couple of years before I got there. I was on the State Bar's Standing Committee on Professionalism for 6 years, which is all you're allowed to be on it, because I did see issues. I mean, as a trial lawyer, you run into people sometimes who think the best way to try to handle a case is to be a bully, or even worse names than that. I didn't like to see that. I also saw young lawyers and talked to trial judges I know who were saying the young lawyers came out not really knowing how to practice law. Through the Professionalism Committee, I was the chair of that for 2 years. I got the Outstanding Chair Award 1 year. But we've gone to Berry and FAMU usually twice a year. And Carrie Ann is now the chair of the Professionalism Committee. But we go to Berry and FAMU twice a year to try to teach them professionalism and also just the plain old practice of law. One of the most fun things that we did early on at FAMU was we had a mock hearing. And I thought it would be the most fun to do everything as wrong as you possibly could, rather than coming over there and showing us how to do it. The kids, and I say kids, the students' jaws just dropped because we just really had a fun time. One lawyer in a jacket, one guy working on his phone, all the rest of this. And they were just mouth hanging open, and so we had a lot of good give and take, and then we went on from there to then, after discussion, to do it properly. I've also done a lot of CLEs, a lot of them on professionalism, some of them on mediation. I got involved in the social media impact on trials several years ago because I read about and heard about some really huge cases that got mistried because jurors were doing their online research on the case they were sitting on, and they were getting evidence online that had been excluded in the trial. Yes. And at the time, there weren't any jury instructions on that. It was, you know, don't go to the scene, don't read the newspaper, don't talk to your family, all that kind of, but nothing about the internet. And so I got interested in that, and you know, learned all the social media stuff, learned the law, and gave a presentation at ABOTA, which I had just joined at the time, on jurors who tweet, blog, and surf to point out what the problem is and to encourage people to adopt standard instructions. In fact, the Florida Bar Committee on Civil Instructions cited to my presentation when they went in front of the Florida Supreme Court, which I thought was pretty neat. I've done appellate practice seminars, I've done mediation seminars. To me, it's part of what I enjoy, teaching people and interacting with people. So that's, I don't know if I missed anything or not.
I think you covered it all.
Okay.
Thanks.
Let me switch gears
Sure.
just a little bit here. What sort of professional and or personal adversity have you had to deal with in your life, and how did you handle that adversity?
In terms of personal adversity, I have been extremely lucky and blessed. I had a wonderful childhood, schooling was great. I met my wife when we were both, well, we met in junior high school, we started dating in high school, and went throughout, been married now 38 years, wonderful mother and father. So personally, I've been just blessed. Professionally, I wouldn't describe it exactly as adversity, but I've had opportunities to work at different law firms. That can be a challenge, I would say, because starting your own business more than once is a challenge financially. It's a challenge to get everything up and going. It's a challenge to deal with your clients. But that role, I think, really has helped me to where I can come in, meet people, work with people in a collegial atmosphere very quickly, and my former partners at different firms continue to hire me either as a mediator, or they refer cases to me, or we co-counsel on cases. So it's been a challenge, but again, I've been very blessed. You know, it's a lot of hard work like everybody else, but it hasn't been I haven't had a mountain to climb, let's put it like that, so,
That's a fair answer, thank you.
yes.
Well, what about the deferred comp suit? Was that one of these circumstances?
Yes, it was. That's when Larry Roth, John Smith, and I left Rumberger, Kirk, and Caldwell. And there was a dispute because without going into great detail, the way the deferred compensation program was set up, you were promised money that there was no way in the world it was there. So they couldn't have paid us if they wanted to. And the paperwork, it's like the cobbler's kids have no shoes. The paperwork, although drawn up by another attorney, was drawn up improperly, but yet we had all signed off on it because we'd seen it and seen the markups and all the rest of that. But when it went around the partners meeting at the table, everybody's just signing away because they had already seen it. So when it got to that, it's like, well, that's not really the deal. So we had to. We were the young guys who left, and the older attorneys were not happy that we left because we left with clients like Disney and Toyota and Honda and Mazda and Safeco and, you know, wonderful clients. I mean, we left with, we had very loyal clients. When we left with a lot of business, and they were not happy, and so they didn't just immediately write us a check. We had to file suit. We worked it all out through mediation, and again, it was a Rumberger Kirk law firm who asked me to come back, and I did join them again, so doesn't seem to be too many hard feelings. And right now, Larry Roth, the other partner who left, he's back at Rumberger Kirk. So it was, you know, it was a business issue, and it got worked out very amicably in a relatively short amount of time.
Does anybody have any other questions? You can go ahead and close.
Okay, well, I thank you very much again. I really, truly would enjoy working in this court. I enjoy this type of work. I enjoy the wide range of issues and the collegial atmosphere that there is. I would certainly promise each and every one of you that if I do get the appointment, I will work hard to do my best each and every day to be fair, to be impartial, and to get cases promptly resolved so that the parties know where they stand and what their future holds. And I would do it in a professional manner, in a manner courteous to those who come before me and with those with whom I work. And I would ask you to please forward my name to the governor with your recommendations. So thank you very much.
Thank you.
Thank you.
That's why I was
You knew this.
Fine much here. You know? Probably a pretty good question.
Yeah.